This is Duke University.
We're about to start our afternoon panel. And this is really a special treat for us. Not only do we have a terrific group of panelists, but we also have the dean as our moderator. And I was telling the dean there's a few things in his bio that I didn't realize were there. So he's getting worried now that I might start making things up, because that would be the sort of thing I would do, but I'm not going to do it in this instance.
Be good.
Dean Levy is the 14th dean of Duke Law School, and prior to his appointment, he was the chief United States District Judge for the Eastern District of California with chambers in Sacramento. He was appointed a U.S. attorney by Ronald Reagan in 1986 and a U.S. District Court judge by President George W. Bush in 1990. One of the things he's told me is that he handled a FISA case, one of the very few people probably in this room, probably the only person in this room that actually handled a FISA case as a U.S. attorney. He graduated from Harvard College, magna cum laude. He entered Harvard's graduate program in history, specializing in English legal history, and serving as a teaching fellow in English history and literature. He graduated Order of the Coif in 1980 from Stanford Law School, where he was also president of the Stanford Law Review. Following graduation, he was a law clerk to Judge Ben C. Dunaway in the U.S. Court of Appeals for the Ninth Circuit, and then to Justice Lewis F. Powell, Jr. of the United States Supreme Court. He has served as chair of 2 judicial conference committees by appointment of the Chief Justice. In 2010, he was named to the board of directors for the of Equal Justice Works. Dean Levy.
Thank you. Thank you for that charming introduction, and welcome to Duke Law School. I'm sure you've been welcomed before, and I know this is a terrific conference. And we have a wonderful panel for you this afternoon to discuss judicial deference and national security. First, the furthest from me, the furthest to the right, is Neal Segal. You might think that Neal Segal was a law student, perhaps, but in fact he's a very distinguished professor of law and political science here at Duke Law School. He's been writing this year very persuasively and in a way that has caused a good deal of attention on the Affordable Care Act. He graduated from Bolt Hall for his law degree. He graduated from Duke Summa undergraduate. He clerked for Justice Ginsburg on the U.S. Supreme Court and was a Bristow Fellow in the Office of the Solicitor General, a very distinguished scholar. Next to him is our own graduate, Nathan Sales, who graduated from Duke Law School in the year 2000. He's an assistant professor of law at the George Mason University School of Law. He teaches national security law and administrative law. He was the first deputy assistant secretary for policy development at the U.S. Department of Homeland Security. That's not the first deputy, it's the first in time deputy assistant secretary for policy development. He apparently wrote the Patriot Act, or as he told me just a moment ago, he took dictation. He did this in 2002, and he did it so well that the Department of Justice gave him an award for that. He's a very prolific scholar, and it's a pleasure to welcome him back to his alma mater. Deborah Perlstein is an assistant professor of law at the Cardozo School of Law, and it's great to have her here today. She's done a number of things remarkably well. Her research focuses on national security law and the separation of powers. She's widely published. From 2003 to 2007, she served as the founding director of the Law and Security Program at Human Rights First. She's a graduate of the Harvard Law School. She clerked for Judge Boudin on the First Circuit and for Judge John Paul Stevens, who will be our graduation speaker at the U.S. Supreme Court. So a very distinguished panel. We're going to talk about national security and judicial deference, and this is an important topic. You'll hear, I think, two broad themes in the presentations today, and each one of our panelists will make a presentation. We'll have some discussion among the panel, and then we'll throw it open to you for your questions and your comments. So one of the broad themes here is to consider, why is national security different from other areas of law and life that judges must deal with? Should we think of deference in national security cases as somehow and in some way different from deference in civil rights cases or patent cases, environmental law cases, tax or criminal cases? These are cases that rely on expertise and experience, sometimes on a sense of social norms and community values. Is it the complexity of the topic, the need for on-the-ground decision-making, or is it in some way because of the allocation of duties under the constitutional system, a need for accountability? What is it that makes national security different, if it is different, from other areas? And second, what do we mean by national security? And what do we mean by war and by terror and such things? If we're referring to national security, do we mean things that pose a threat to the current life of the nation in some time-bounded way, or do we mean something that could be a threat over a long period of time? Would we consider a threat to our economy to be a national security threat? Would we consider a threat to our information systems to be a national security threat? And then where will the lines be drawn? Now, you'll see in some of the articles, and you may have read them, that there is some talk about deferring, the judges should defer to fact-finding, not to legal finding, because that's what judges do, but to fact-finding. And of course, this is an old question in judicial review of agency action. What do we mean by facts? It might be a question of fact as to where a particular person was detained. Were they detained on a battlefield? Or it might be that we have to consider the application of law to those facts. So what is a battlefield? Well, that might actually not be a factual judgment so much as a mixed question of law and fact. And it's hard to draw those lines between what is a pure fact and what is actually the application of law to fact. And then I think we'll hear two minor themes. The law-politics distinction, for example. In these kinds of debates where you have a question of procedure, in a sense, which deference is, does one defer across the board? Or does one, as scholars will want to ask, and maybe judges to some extent will want to ask of scholars, are you only in favor of deference where you like what the agencies are doing? And are you only in favor of court intervention when you have a high degree of confidence that you'll like what the court is doing? In other words, is your fidelity actually to some constitutional separation of powers or allocation of powers, or is your fidelity to the outcome? And so, depending on the outcome that you seek to achieve, then you'll either be in favor or not in favor of judicial deference, depending on what you think the judges are likely to do. When I hear talk about law versus politics, I always like to dwell for a moment on what we mean by politics, because sometimes it has a negative ring to it. And I think we should distinguish between partisanship, which is a form of political activity, and not necessarily a bad form, depending on where it comes up, and politics in the sense of policy, judicial philosophy, or even the philosophy that a scholar might have. So judges in our system, our federal judges, are chosen by the president and confirmed by the Senate, and they do have, we know this, different views of the Constitution. They weight different social values differently. That is not a criticism of the system, that is the system. And so too, academics and scholars have different points of view on these very same issues. And to the extent that legal questions become political questions in our country, and political questions become legal questions, which is often the case. There can be a lineup as between the two political parties as to how one feels about certain issues, and so that may tend to be the Democratic position versus, let's say, the Republican position, or the liberal position versus the conservative position. But these are not necessarily bad things. These are just the realities. But I would ask our panelists to consider whether they would hold judges to a different standard than they would hold the academic community. And that might be an interesting question. And then I think history is another important factor in all of this. It's hard to think about the history after 9/11 without thinking about how it has changed over time and how courts may tend to want to defer right after 9/11, during a time of crisis or uncertainty. But then the more time that goes on, the inclination to defer to the executive branch or even to the legislative branch seems to diminish to some extent. And that may be the product both of a sense that the danger to the nation has lessened, or maybe it's also a sense that the other branches needed to have a certain amount of latitude to get their act together, so to speak, and that after a certain amount of time, the courts then should be less deferential. And that is a kind of judicial, I would say, artisanship or craft, which you won't find in the Constitution, but it's just simply one of the factors that goes into being a good judge, perhaps what Professor Siegel would call judicial statesmanship. It's not a matter of logic, it's a matter of timing, and timing can be very important in judging as it is in other areas of life. So, Professor Siegel.
Well, thank you very much, Dean, and I want to thank General Dunlap as well for making this conference happen and for inviting me to participate. I want to thank you folks as well for being here today. I welcome you as well to Duke Law School. The phrase national security judicial deference is a broad and encompassing one, as the Dean just noted. So I thought I would begin by unpacking it a little bit. Right? It's possible to talk about deference to the executive and compare and contrast it to deference to the Congress. One could focus just on the executive and talk about deference to the executive's determination or interpretation of the facts, and deference to the executive's interpretation of the law, whether that be federal statutes or various treaty obligations. There's also the complication, as the Dean mentioned, of mixed questions of law and fact. One could talk about national security generally, which will mean lots of different things to different people, or terrorism in a post-9/11 world specifically. And of course, we can carve up terrorism cases and questions in all kinds of ways. We could focus on targeted killing, we could focus on coercive interrogation, we can talk about military detention, military trial, civilian trial, electronic eavesdropping, the scope of the state secrets doctrine, military preparedness, and the applicability of the Constitution outside the United States. And so what I thought I would do in the next 13 or 14 minutes or so is exhaustively cover all of those subjects. All right, I'm going to try and be less ambitious. There have been law professors who think they can do that. I'm not one of them. My focus is going to be on deference to executive fact-finding in national security cases implicating claims of individual liberty. Right? So a paradigm example is indefinite military detention of an alleged terrorist in the U.S. at Guantanamo Bay, somewhere else in the world, a U.S. citizen, right, an alien. Claims involving fact-finding, national security, claims of individual liberty. The puzzle I want to put on the table is why, both historically and today, federal judges often embrace arguments in favor of judicial deference to executive fact-finding in this context, either explicitly in what they say or implicitly in what they do, notwithstanding what they say. Now, of course, you might ask, why is this a puzzle at all? Right? There are some very important arguments, very judicial arguments, in favor of judicial deference to executive fact-finding. First, the executive branch officials have better access to information than you generalist judges, and thus the argument goes they're more likely to render factually accurate determinations than are the federal courts. Second, executive branch officials have much greater experience and expertise in national security matters than do generalist judges. And again, they're more likely to render factually accurate judgments than are the courts. And third, we often hear arguments about democratic accountability. Decisions touching on questions of war and peace, life and death should be made by democratically accountable government officials, not unelected judges. To be sure, there is obviously something to these arguments as a general matter. And frankly, I think it would be foolish to deny that. But what I do want to suggest is that these arguments can be unpersuasive in their particulars for at least 8 different reasons. First, deference on grounds of information access, on grounds of expertise, makes sense only insofar as the executive branch actually uses its informational and expertise advantages in an impartial manner. And I believe Deborah Perlstein has written about just this subject. Absent such a showing, the case for deference, it seems to me, is substantially less strong. Second, democratic accountability values are relatively strong with respect to prospective fact-finding, predictions about what might or might not occur in the future. But it seems to me such values are relatively weak with respect to retrospective fact-finding. What happened? Is this person who the government says he is? Why did Yasser Isam Hamdi, what was he doing in Afghanistan at the time he was picked up by the Northern Alliance? What was Jose Padilla up to before he was picked up at O'Hare Airport? What was he planning on doing when he got here? Right? These are, in significant part, factual questions about what happened. And if we care about the truth of the matter, it's not clear to me why democratic accountability standing alone suggests why the executive should be able to make that determination. Third, courts can require executive officials to share factual information. They don't have to go on their own fact-finding missions, and courts are very good at preserving confidentiality, national security secrets through various mechanisms like ex parte proceedings. And what is more, the adversarial process itself can bring new information to light that we wouldn't have if we just relied on the executive. Fourth, executive branch officials responsible for the country's security have long tended to overstate the dangers facing the nation, whether due to honest mistakes, attempts to avoid public embarrassment, self-protection in case they fail, or a desire to persuade Congress and the public to give them more and more authority. Fifth, executive branch officials responsible for the country's security historically have tended not to be especially sensitive to the importance of constitutional liberties, and thus have too readily sacrificed them in the name of enhancing security. Sixth, we have had opportunistic politicians in our history who have exploited fears, real or perceived, during crises for partisan or personal advantage. Jeff Stone has written about this extensively in his book, Perilous Times, as well as elsewhere. Seventh, what we now call the war on terror may last forever. It may last forever. We soon may reach a point in which the executive branch takes actions with respect to alleged terrorists that won't be during a time of U.S. participation in a foreign theater of military operations. And so a narrow or limited rationale for executive power that the Supreme Court invoked in previous cases, the case involving Hamdi, may no longer be available. If we're talking about forever, it seems to me there are different considerations than if we're talking about just during World War II, for example. Eighth, and controversially, but I think importantly, policing deprivations of individual liberty by order of the executive with or without the approval of the Congress is central to the judicial function in our separation of powers system. And so if we want to begin to answer this good question about, do you believe in deference across the board? Do you believe about it in just some cases and not others? Right? How do we discipline ourselves to the bridge of consistency? What distinguishes one setting from another? I think part of the answer, perhaps the most important part, is a vision or a background understanding of what the role of the courts is in a separation of powers system. And what I'm suggesting is that when you're talking about the president putting someone in a brig, potentially for the rest of their lives, that kind of claim of individual liberty implicates the function of the courts in the ways other kinds of separation of powers disputes, other kinds of federalism disputes do not. So in sum, or at least to summarize many of these 8 reasons, there are many instances in U.S. history of the executive branch and deferential federal courts under-protecting liberty without any demonstrable increase in security. The Japanese internment during World War II is just a dramatic example of this. I know of no instance in which the executive branch or federal courts have overprotected liberty with a demonstrable decrease in security, notwithstanding what certain critics have said, including certain current Supreme Court justices in dissenting opinions. And if I'm wrong about that, please, I encourage someone to correct me. Now, to be clear, I'm not suggesting history is decisive. The world has changed in important ways. The technology now exists for a small number of terrorists to kill thousands, potentially tens of thousands of people in a single incident. Right? So I don't think history is decisive in the way, frankly, Justice Scalia sometimes thinks it is in one of his terrorism decisions, again in the Hamdi case. But I do think that history should counsel some caution in deferring to executive fact-finding on a permanent basis in cases involving deprivations of individual liberty. Now, if I'm right that the federal courts, through words or deeds, have tended to give judicial deference to executive fact-finding more than it's due in these kinds of cases, what explains the behavior? Why are they doing this? The answer is surely complex, surely overdetermined, but I think part of it may have to do with prudential concerns, prudential reasoning. And here I'm going to talk about the law-politics distinction that the dean mentioned. And I'm thinking specifically of two kinds of prudentialism, which I've written about in some of my own work in a different context. The first I call system-centered prudentialism. This focuses on the good or bad consequences perceived by a judge of a particular decision, whether for the constitutional system or the nation as a whole. The consequences of overprotecting liberty in national security cases can be catastrophic, for the reasons I just mentioned. Courts are thus loath to second-guess executive fact-finding, even if there are good reasons to doubt it in particular cases on grounds of information access, expertise, and accountability. The second kind of prudentialism I call court-centered prudentialism. Here, I've argued that courts have to take some account of the conditions of their own public legitimation, which requires judges to anticipate the reactions to their decisions of presidents, members of Congress, and the general public. Fear of backlash may be especially great in certain national security settings, which is why judicial concerns about institutional self-preservation can be acute here. These prudential considerations can manifest themselves in threshold determinations of jurisdiction. For example, the political question doctrine, the idea that the Constitution allocates certain kinds of decisions or judgments to the political branches, not to the courts. These prudential concerns can manifest themselves in cases in which the courts have asserted jurisdiction of deciding the merits, specifically in the form of excessive judicial deference to executive fact-finding. Now, if I am right, and if you think I'm wrong, just pretend I'm right. If I'm right, why don't courts just say so? Right? If they're thinking and reasoning prudentially, why not just come out and say it and be candid and transparent about it, and we can all evaluate the strength or the weakness as well as the propriety of their prudential thinking. Why instead make what is sometimes an unpersuasive case for fact deference to the executive branch? Why, in other words, are prudential considerations unspeakable? Unspeakable by judges. And here I think there is a fear that prudentialism is incompatible with the judicial role. That prudential thinking is political in nature, not legal. The truth of law's own application may conflict with the preconditions of its public legitimacy. In other words, judges who practice the kind of prudentialism I'm talking about may perceive an irreconcilable conflict between the sources of the law that they're actually fashioning and the conditions of its legitimacy in the eyes of the public. I don't think this problem is unique to the national security context. Writing decades ago, a famous political scientist, one of the smartest there ever was, by the name of Martin Shapiro, at Berkeley Law School, he insisted that the distinction between what the court says to the public about what it is doing and what scholars say to one another about what it is doing must be held firmly in mind. It would be fantastic indeed if the Supreme Court, in the name of sound scholarship, were to publicly disavow the myth upon which its power rests. The concern here is that the legitimacy of the legal system depends on the popular belief or perhaps fantasy that judges decide cases impartially based upon pre-existing law that is fully autonomous of political considerations. I think this belief explains many things, including the great political success of Chief Justice John Roberts during his Supreme Court confirmation hearing, when he made a famous analogy, an analogy between baseball umpires and Supreme Court justices. Justices are like umpires, he said, notwithstanding the obvious vulnerabilities of analogizing a Supreme Court justice to an umpire. If they're just umpires, why on earth does he want the job? When do all-star pitchers hang up their cleats to become umps? Right? It doesn't happen for a reason. I could go on, right? If you want to, if baseball would be like being a Supreme Court justice, if the rule said something like this: the batter shall have a reasonable opportunity to hit the ball. A hit ball is foul if, in the reasonable judgment of the umpire, the fielder didn't have a reasonable opportunity to field it. Then we have lots of fights about who's calling the game before we ever get to play. It follows from this account of judicial legitimacy that prudential reasoning, which is prospective in outlook, it requires the exercise of discretion and judgment, over time will disillusion the public, who will construe such reasoning as evidencing the assertion of merely political power, political in the bad sense of the term. So under this account of unspeakability, the very jurists who exercise discretion, who employ the distinctly human faculty of judgment, may conclude that the constitutional system in which they're operating, or the courts on which they sit, are best served if they deny this fact. And regardless of whether such concerns about the consequences of full transparency, of full judicial candor, are well-founded, they should not be confused with the truth of the matter. All right, so what are the implications of what I'm saying? I guess one answer is who knows. This is difficult stuff. I'll lay three on the table. You can consider or reject. Maybe you'll have some of your own. One is jurisprudential. The other I'll call political in the good sense. And the last I'll call human or personal. Jurisprudentially, if we think of transparency and candor as a core virtue of the rule of law, it's something we ordinarily ought to promote. And if we think that judges are not about to stop reasoning prudentially, at least to some extent in national security cases, and if we think they ought not to stop reasoning prudentially, at least to some extent in such cases, because the consequences can be so great, then perhaps we need a better conception of what it means to be faithful to the law than is embraced in the umpire analogy and other statements. Justice Sotomayor talked about fidelity to the law. I think she was echoing the Chief Justice. Chief Justice Marshall used to talk this way all the time, although it's clear from his private writings that he did better. The lesson, in other words, may be that we still require theory that can face fact. That's how Llewellyn bluntly put the point in 1934, or as Cardozo instructed us in 1921, we must seek a conception of law which realism can accept as true. And I don't think realism can accept as true a conception of law that always equates the kind of prudentialism judges sometimes engage in national security cases with lawlessness. The political implication goes something like this, and I think it's directed to all of us. If we want federal judges to pay due regard for individual liberty in national security cases, if we want them to be rights protecting and not just self-protecting, then it seems to me we ought to work hard to publicly defend the independence of the judiciary in such cases. I think the rule of law is not self-enforcing. There are political foundations of the rule of law, political support for judges exercising the power they do. And so if we want to see that in various national security settings, then we need to do that kind of political work, it seems to me, ahead of time. And then the last, the human or the personal dimension, I think is simple but important. The dean would certainly know much better than I. Being a judge can be hard. It can be hard to be a judge. It can take real courage to stand up to an executive assertion of fact in a national security case, to look at the evidence and say no. Thank you.
Thank you, Neal. Deborah.
Thank you. Well, thank you also to General Dunlap, Dean, my fellow panelists. I'm just delighted to be back at Duke for what is always one of my favorite conferences of the year. So I took the question to the panel, or one of the many good questions to the panel, to be a normative one. Should the courts defer to the executive in national security cases? The significance, as we've heard a little bit of the question, is, I think undoubted. We've seen the courts repeatedly struggle over the last decade alone with how to interpret the statutory authorization for the use of military force passed after 9/11. To what extent does the necessary and appropriate force to which Congress delegated the president to fight those responsible for the attacks of 9/11, to what extent does that include the power to detain, the power to engage in wireless surveillance, the power to create new courts, have all come before the courts in one way or another and have required in the first instance that the court interpret the meaning of necessary and appropriate force within the terms of the statute, along with the meaning of various relevant treaty obligations, including Common Article 3 of the Geneva Conventions, to which the United States is, of course, party. So the significance, I think, is clear. The answer I want to offer is, the answer to the question, should the courts defer, is, well, depending on what we mean by deference, right, mostly no. So what I want to do here, I think, is three things. One, I want to say a little bit about what I mean by deference. And as Neal was just saying, there are a lot of different ways of thinking about it. I think most useful for our own thinking is probably narrow the definition and talk about it piece by piece. Then I want to say just a little bit about how this has been playing out in the courts post 9/11. I know, I think Nathan is going to talk a little bit about the Supreme Court cases, obviously, in the last decade, and this being centrally relevant in cases like Hamdi, Hamdan, and so forth. I want to mention just a few words about how this is playing out in the D.C. Circuit just in the last year or so. And then mostly, I want to make the normative case for why I worry about deference in the sense that I want to describe it here. I'll make my own case and then spend most time, I think, addressing some of the key counterarguments that's part of the instinctive reason why so many of us think the court should defer. Okay, so what do I mean by deference? Well, one way of at least distinguishing the topic is to say, well, are we talking about deferring to the executive on questions of fact, right, or on questions of law? Deference on questions of fact raises an enormous number of questions, right? And I'm happy to talk about those in Q&A. What I want to talk about right now is deference on questions of law. That is, what does the AOMF mean? What does it mean, necessary and appropriate force? Should what the executive says, necessary and appropriate force, means go, at least as far as the courts are concerned? The courts have actually encountered this question a lot, and not just in the national security context. Most famously, of course, in the administrative law context, or most famously for most law professors, in the administrative law context, in the Chevron doctrine, right, from back in the 1980s, where the Supreme Court says, look, if a statute is ambiguous, a statute delegating authority to an executive agency, if we get to the point of interpretation and we can't decide exactly what it is the statute means, we stop our own interpretive inquiry and defer to whatever the agency says the statute means. So-called Chevron Deference, and I know, again, Nathan's going to talk about this a little bit more. This is the kind of deference that most people have argued, at a minimum, Chevron-type deference, is the kind of deference that the executive should be afforded in interpretation of national security statutes and treaties, right? So if the term, say, necessary and appropriate force, for example, is ambiguous, the court could look to traditional tools of statutory interpretation, policy, other sources, what Congress was trying to accomplish in the act, legislative history, and so forth, or it could simply take the executive's word for it. And a lot of people have made that argument, both before 9/11 and after, in the context of various statutes. Interestingly, then, one would expect, right, to see the courts at least showing Chevron-type deference to the executive on the meaning of statutes and treaties post 9/11. But I've argued in various places that I don't think the Supreme Court has been doing that. And interestingly, the lower courts don't seem to have been doing that much either. So let me pick what I think is one of the more recent interesting examples, right? So all of the habeas cases, the Guantanamo detainees have been challenging the legality of their detention through the federal courts. There have been several hundred of these habeas cases brought, and they have now almost all made their way up and through the D.C. Circuit. The Guantanamo detainees have never won a case in the D.C. Circuit. That is a case in which their release has been ordered, or indeed their habeas petition has been granted. They won many of their cases in the district courts from various judges, but the D.C. Circuit has never has rejected all of these claims. It's not, however, because the DC Circuit is deferring to the executive, either on questions of law or questions of fact. So interestingly, in the key DC Circuit decision a couple of years ago, 2010, I think, in which the court was wrestling with what should the standard be under the AOMF, who can be detained as a matter of necessary and appropriate force. The executive argued the meaning of that term within the statute should be informed by international law, and in particular the Geneva Conventions and applicable international humanitarian law governing who may be detained in various kinds of armed conflict. The DC Circuit panel decision categorically rejected the executive's interpretation of the AOMF in that regard. International law, the court said, is completely irrelevant. It didn't quite say, I don't care if the president says it's irrelevant or not, but it came pretty close to saying just about that. In fact, the panel decision was sort of so remarkable in those terms that although the en banc court in the DC Circuit declined to review that particular case, there was little question that that particular detainee wasn't entitled to habeas. They issued a set of opinions trying to address the extent to which they didn't necessarily embrace the view of the panel wholeheartedly about the relevance of international law and so forth. Nonetheless, that panel decision is the DC Circuit's last word on what the executive's view of the meaning of the AOMF should be. Similarly, the executive has taken a position in the habeas cases that detainability or not should be evaluated based on a preponderance of the evidence, right? So how much evidence do you need to demonstrate in these habeas cases to show this person should be detained? The lower courts, and to some extent, the DC Circuit have embraced this preponderance of the evidence standard put forth by the executive. But you have this sort of repeated practice by the DC Circuit made, I think, most explicit in a series of concurrences by Judge Silberman on this court, saying, you don't need a preponderance of the evidence. Some evidence is fine. Now, interestingly, in Hamdi, of course, the Supreme Court addressed the some evidence enough standard and said, no, that's not sufficient. The DC Circuit seems to be developing a different view of that question, but nonetheless, Silberman has argued quite persuasively, at least to Judge Silberman, that, look, requiring more evidence in this kind of setting is both unnecessary and unrealistic. So despite the executive saying, we couldn't realistically provide you with the preponderance of the evidence in these cases, the judge is saying, it's unrealistic that you should be able to provide us with that amount of evidence, right? It's a striking contrast for the kind of behavior one might imagine we would see, right, from the court, even in the realm of Chevron deference, much less something more vigorous like what one might have imagined we would see in a national security setting. Okay, so if that's what's happening, right, we can ask why that is, and we'll talk more about that, I know. I want to ask whether that's the right thing that should be happening. And I've written about this in various places, but let me just try to briefly summarize in the time we have here. So what should courts do about law interpretation, right? What is the court's job? And one can think about the answer to that question, I think, in a variety of different ways. One can think about it in formal terms. What does the Constitution say the courts are supposed to do when confronted with the meaning of, say, a statute or a treaty? One can think about it in functional terms, right? What were the framers trying to accomplish when they established this scheme of separated powers in the first place? What do we think they should be trying to accomplish? And you can ask it finally in a much more immediate way. What works? What's effective, right? You could ask about the framers and functionality in those terms, but we live in a different world today. How should we evaluate what works in that world, and shouldn't we pursue that model? So I actually think along all three of those inquiries, right, it argues against deference, or at least for active judicial review on questions of law. So in formal terms, most famously, we have Marbury versus Madison, right? The judicial power includes, centrally, the power to say what the law is. And although Marbury even carves out or suggests there is this category of political questions that may arise, right? If the court decides to hear a case, and in all of the cases we're talking about today, the court has said this case is justiciable, right? There was no suggestion in Marbury of deference once the court decides to take a case, right? So this is the formal judicial power. This is the constitutional baseline in the absence of some reason or some new theory, right, to the contrary. What were the framers' functional reasons for separating powers in the first place? Well, most famously, and Neal, of course, eloquently spoke to this, the central reason for separating powers was for the protection of individual rights. So you had the framers, Madison in particular, arguing against the creation of a separate Bill of Rights attached to the original Constitution, not because he didn't think individual rights and liberties were important, quite the contrary, but because he thought the whole purpose of having divided government among the branches, checks and balances and so forth, was in order to protect rights. Rights would be protected vigorously simply by virtue of having a Congress and a president and an independent judiciary all engaged in their protection. The framers were also worried centrally about the sort of tyranny of the majority idea. So the idea that on some issues in particular in politics, passion would tend to swamp reason. And those issues are better dealt with, at least participated in, by a more politically neutral branch, a branch that is less removed from the passions and factions of day-to-day political life. Now, historically, the framers were worried about property. They were also worried about, for example, treaty negotiations, so they didn't want the House to be involved in treaty ratification because they thought everybody in the House is sort of nuts and can't keep a secret, and there are too many of them anyway. I paraphrase the framers here. In more modern terms, right, we've thought about issues affecting discrete and insular minorities. So there are some issues that obviously the legislature has the power to legislate about, although we'll learn more about Congress's power, I suppose, in June. But even though the Congress has the power to engage here, right, we might worry about particular kinds of interests not being effectively represented through the standard political process. Okay, so those are sort of the functional justifications for why we wanted judicial review as a general matter, judicial interpretation as a general matter. I tend to think they still stand, and perhaps stand even more vigorously for some of the reasons Neal described. You might finally think about things in terms of these functional interests in terms of contemporary studies. So there's been a lot of work over the last decade, but really the last several decades, in fields like organization theory. This is the field that looks at how organizations should be designed to accomplish various functions. And there is a great deal of scholarship and practical scholarship on how organizations should be designed to deal with emergencies, how organizations should be designed to deal with low-risk, high-consequence bad outcomes. So, for example, we fly planes all the time. We've been flying planes for a long time. How do you make sure the planes don't crash? How do you design an organization that has a sufficient number of checks in it to make sure that the planes don't crash? Similarly, with the maintenance of nuclear weapons, the maintenance and management of nuclear power, all of these things are questions that organization theory has looked at closely. They've all mostly come to the conclusion that monitoring and review systems can be effective and can contribute in many ways, both in terms of error correction and enhancing accuracy of decision-making, in promoting organizational learning over time. But one of the central lessons here has been that whatever review structure you have, it shouldn't duplicate the first-order decision-making process. It should be structurally and culturally independent to avoid what one of my favorite scholars in the field has called the problem of redundancy problem. That is to say, right, I love him. Scott Sagan is a Stanford scholar. Should have been a writer. In any case, the problem of redundancy problem, right? If you're building a car and you have a mechanic in the first instance or a car builder in the first instance who knows that somebody really smart is going to be checking his work down the road, he can use a little less care in building the car in the first place because he knows he's got a check backing him up. If the check you then have, right, is deferential by design, that is, the check says, well, you know, there was this really smart car designer, car mechanic working on it in the first instance. We can give a sort of more cursory review in the second instance. This has already been looked at once. they'll be less likely, or in a deference type regime, by design, they are less likely to look closely at what happened in the first order. So deferential type review mechanisms create, to some extent, the worst case scenario, right? You develop an incentive for shirking in the first instance, and in the second instance, you don't sort of fulfill the expectations that you've built up in the first instance. In other words, deferential review, given the incentives it creates inside an organization, may be worse than no review at all. Okay, last about organization theory. So why is it that so many people historically have argued the court should defer to the executive on interpretations of law? And there are a bunch of really important arguments here. Let me cite three and give a few thoughts about each of them and why I think they're ultimately unpersuasive. Argument one is, well, yes, the court has formal judicial power to say what the law is, but the executive has formal constitutional power too. It has the commander-in-chief clause, it has the vesting clause, the clause giving executive power to the president. And these clauses, especially in the national security context, give the president some formal constitutional power to interpret the law. I actually agree that those clauses probably give the president some law interpretive power, in part, or at a minimum, because the president also has the constitutional duty to take care that the laws are faithfully executed. How can he take care that the laws are faithfully executed if he doesn't have at least some first-order reading on what it is the laws mean, right? Similarly, most of any kind of issue the executive might be faced with never get to court. Courts only decide this tiny fraction of cases, so the executive branch is engaged in law interpretation all the time. The question is not whether the executive has some formal power here. Let's posit that he has some. The question is whether he has more formal power, or if there is a dispute as between the executive and the courts on what the meaning of a particular law is, who wins in that setting. We saw some arguing that the executive's view of, say, the Constitution or even statute should trump the view of the courts in the post-9/11 setting. I think this is that notion that the interpretive power, whatever it is that the executive possesses, is greater than that of the courts, I think is a very difficult argument to make, and we can talk more about that if you like. The second big argument that is made in favor of deference is back to these functional grounds. That is, the executive knows a lot more about national security than the courts. The executive is not only in possession of more facts, the executive has more experience, more expertise, is simply better able to evaluate what Congress might have meant by necessary and appropriate force, indeed what necessary and appropriate force really is. I think this consideration actually ends up arising a lot more in questions of factual deference than legal questions. But the second thing is that I think is important to say is that there are lots of ways that the court can take into account the executive's expertise in this regard, short of cutting off its own inquiry into meaning. Before Chevron, in the administrative law context, we had Skidmore, right, another Supreme Court standard from the 1940s that said the executive has all kinds of incredibly important knowledge and wisdom at his disposal. We should listen to what that is and take account of it to the extent it has the power to persuade, right? This was the court's language. Skidmore, I think, gives us gives the courts an enormous amount of leeway to take account of the executive's views, short of simply saying whatever the executive says goes. This is related to the final point I want to make about functional expertise, and that is models like Chevron and so forth, that is, models of deference that simply say whatever the executive says goes, don't necessarily capture the expertise that we're most worried about. So in Hamdan, for example, the military commission's case, the political executive, the president per se, made the argument in pretty short order that, well, yes, military commissions are necessary. And there was no particular record that supported that. There was no particular analysis out of the executive branch in the briefs or elsewhere that supported that. At the same time, the court had in front of it a lot of briefs, both by the JAG lawyers who had been appointed to represent the military commission defendants, JAG lawyers who had filed amicus brief, retired military leaders, including retired admirals and generals, who had filed briefs, New York Times articles, and many other sources saying, gosh, you know, the experts inside the Pentagon were cut out of the process of commission creation the first time around. If what you're really interested in is accessing the expertise within the executive on these questions, you need to look beneath exactly what the executive, the president alone, that is, said. Pure deference regimes make it difficult to do that. That's a complicated question in a lot of ways. I have a separate article on that, but I'll leave it to Q&A if you want to talk about it. Final point, political accountability. So the argument is, look, there is something especially politically salient about national security issues, more than patent law, more than health care, more than environmental law, right? Something that requires us to not include the apolitical courts in the calculation. The more politically accountable branches should have more say in what we mean when it comes to questions of national security. So I have a couple of things. One, I'm not sure I buy the argument that national security questions are more political than any other kinds of questions the U.S. government faces. And in particular, as we see a collapse of the distinction between what kinds of issues are foreign and what kinds of cases are domestic, right? We used to distinguish the court's docket in that way, but gosh, everything has foreign affairs implications these days. And we see a broadening of the category national security. We're not just talking about war fighting. We're not just talking about nuclear weapons. People are talking about environmental security. People are talking about energy security. People are talking about domestic terrorism. All of these categories that didn't used to be a part of this sort of specialized national security field. As we broaden the exception, we risk swamping the rule. That is to say, the notion that we have this sort of cabined exceptional world of national security law, I think, is becoming, as a matter of fact, harder and harder to sustain. If we really cabin all of that off from what the courts can do, we risk lopping off the courts from a substantial amount of what we do as a society and a government. But let's assume, for argument, that national security issues are more political in some important ways, that political accountability is especially more important here. I actually think judicial engagement on interpretation of these questions better serves political accountability than judicial deference, and I think that for two reasons. One is political accountability can't work without an informed electorate, right? You have to know what you're voting on. It's central to theses of political accountability. Because national security tends to be secret, necessarily so, right? It's easy, and in fact was the case repeatedly in the post-9/11 years, and indeed still, that the executive was keeping its theory of the law, its theory of legal power, secret as well. Judicial engagement makes it impossible to keep the theory of legal power. How much power do you have? How are you exercising it? Why, right? Not sources and methods, not facts, but what is your theory of power? It makes it possible for those to be made public. It makes it possible for accountability to actually function in a security setting. And finally, the courts can have a democracy forcing effect. So before Hamdan, for example, comes down in 2006, Congress was criticized up one side and down the other for saying nothing, doing nothing on questions of national security. Here is our centrally representative branch of government, and it is very happy, for a host of reasons, to cede entire control over a host of centrally political questions to the executive alone. The court's engagement forced Congress to act. It forced a dramatic and vigorous political debate in the public sphere about whether we wanted military commissions, and if we did, what we wanted them to look like exactly. And the result of that was two mammoth pieces of legislation that were passed by bicameralism and presentment and well-known and available to the public. That's a democracy-enhancing effect. That, to me, is political accountability, and that's something that the court, at least in the last decade, we've seen making more possible rather than less. I'll stop there.
Thank you. Nathan.
Thank you, Dean, for moderating today. And thank you, General, for hosting us all. It's a pleasure to be back at my alma mater. I actually think I took tax law in this room. Hopefully today turns out a little bit better than my grade in that class. So what I'd like to do is look at national security law in particular detention and military commissions law, through an administrative law lens. Before I do that, though, I want to sort of take the bait that Neal put on the table. Are there any examples of courts or other decision makers overprotecting liberty in a way that has had negative implications for security concerns? Yeah, I think there's actually at least one, and that's the FISA court wall. FISA court and Justice Department bureaucrats interpret FISA to prohibit information sharing between intelligence personnel and law enforcement personnel, ostensibly to further Fourth Amendment values against unreasonable searches and seizures. Well, it did that, but it also kept the CIA from telling the FBI that two of the people who eventually hijacked planes in 9/11 are in the country. Right, and you have an email from an angry FBI agent who learns that the CIA has this information and says, people are going to die because you didn't tell me. And he was right. So I actually think there's at least one example, and we can talk about the details of that in the Q&A, and whether the type 1 errors are worse or the type 2 errors are worse. But that's sort of a distraction from the point that I'd really like to focus on, which is what can administrative law teach us about national security law? So the framework I'd like to propose is the following. When the national security bureaucracy makes a decision, it's engaging in the same sorts of processes, or at least sufficiently similar processes to what goes on in the domestic regulatory context all the time. So the National Labor Relations Board has a statute that prohibits unfair labor practices. The board has to give some sort of interpretation to that. It then has to issue certain fact findings. Did General Electric in fact do X, or did it in fact do Y? And then it has to apply the law as it understands it to the facts. Well, national security bureaucrats, and I don't use the term bureaucrat as a pejorative, but rather as a descriptor, national security bureaucrats produce the same sort of administrative law outputs all the time. So you can think of detention in a similar way. We know that domestic and international laws of war allow us to detain those who are enemy belligerents or enemy combatants. So, well, what does that mean? We have to assign some sort of meaning to that legal concept. We then have to find out whether Hamdi received training, or whether he took up arms, or whether he merely gave a speech in favor of al-Qaeda. And then we have to apply the legal standard to the facts. So the outputs that are produced by national security agencies aren't really all that different in kind from the outputs that we see from the EPA or other features of the modern administrative state. So the claim I'd like to make is that, well, in the domestic law context, and I'm focusing primarily on judicial deference to administrative agency legal interpretations. In the domestic law context, it's fairly commonplace for agencies to enjoy, again, fairly strong measures of deference. And my claim, the normative claim, is that at least as much deference should be shown by courts in the foreign affairs and national security context, where you have national security agencies issuing legal interpretations of ambiguous legal texts. Let me give you a quick roadmap of what I hope to talk about. First, I want to talk about why we have Chevron, why we have a deference regime for the domestic regulatory state. Second, I'm going to talk about a couple cases where the court has been somewhat unwilling to extend deference in the national security and foreign affairs context. And I'm going to wrap up by offering one hypothesis as to why the Supreme Court has been seemingly less reluctant than you might otherwise have predicted. So why do we have Chevron in the domestic regulatory context? So the test, it's a famous two-step test. Administrative law professors like to make a joke about the Chevron two-step because there's not all that much that's funny about administrative law. That's all we have. So the first inquiry is the statute ambiguous or silent on the question at issue? If it is, we move on to step two. And at step two, courts must defer to a reasonable or permissible interpretation offered by an agency. Notice there is still a judicial role at step two. So I would quibble a bit with Deborah's characterization of the Chevron inquiry as one that cuts off judicial interpretation. I don't think that's right. It's just that the judicial inquiry at step two is different. Instead of asking what is the one single interpretation of this statute that is the best among the universe of possible interpretations, the Chevron step two inquiry asks courts to say, all right, within the range of reasonable and unreasonable, where does the executive interpretation fall? Is it outside the bounds of reasonableness, or is it inside outside the bounds of reasonableness. So there's still a judicial role there, although it is, to be sure, a fairly deferential one. So why do we have the Chevron two-step for the domestic regulatory state? There are at least 2 or 3 different explanations, and we've heard them from both Deborah and Neal already, and they are expertise and accountability. I actually don't think the term expertise really captures what we're talking about here. What we're ultimately talking about is comparative advantage. It's not so much that domestic agencies have expertise. It's that they have more expertise than Article III judges do. So the key concept here, at least in my mind, is comparative advantage. So what kind of expertise could a domestic agency like the EPA have more of than courts? Well, one thing they know more about is the simple facts. EPA knows more than the DC Circuit does about the likely effects when different types of emitted chemicals interact with one another, and what's the likely probable effect going to be on deforestation, on global warming, or any other environmental malady, right? There's a second form of expertise that the EPA has a comparative advantage over courts, or at least the Chevron doctrine assumes this to be the case, and that's interpretive expertise. The idea is that the EPA is more likely to know what Congress had in mind when it enacted the Clean Air Act and said, issue national ambient air quality standards that are requisite to protect the public health with an adequate margin of safety. Right? Courts could figure that out, agencies could figure it out, but the Chevron doctrine says agencies are simply better at figuring out Congress's probable intent than we in the judiciary are, right? So there's sort of 2 glosses on expertise and comparative advantage. The third, and in my mind, the most important consideration is accountability. The idea is that when an agency is called upon to interpret a statute that has a gap, whether a silence or an ambiguity, that process of filling in the gap inevitably involves policymaking. Right? It inevitably involves the decision maker to decide certain values are more worthy of protection than others, and certain means of protecting those values are more effective than other means. Right? So the Chevron insight is that when a decision maker makes that decision and fills in the gap, it's better for that decision maker to be accountable to voters than it is for that decision maker to be insulated. Right? And it just so happens that agency bureaucrats are, well, somewhat insulated. They don't run for election. They are accountable to the people indirectly through quadrennial presidential elections, and also through informal means. If the Attorney General is controversial, the President can fire him or her, right? Anyway, the Chevron insight is that the assumption underlying Chevron is that when an agency fills in the gap, it's not really engaging in interpretation at all. It's engaging in construction. It's exercising a law-making function rather than a law-interpreting function. Another way of putting this is that the agency is exercising delegated legislative power from Congress, right, rather than arrogating to itself the judicial power to interpret the law from an Article III court. This, I think, will become important later on when we talk about how we can reconcile the modern administrative state with its deference doctrines, and Marbury v. Madison and other cases establishing the power of judicial review. Right? So now for my normative claim, and that is the reasons we have a deferential regime in the domestic regulatory state are even stronger in the national security and foreign affairs context. If we buy the legitimacy of a deference regime for the EPA, a fortiori we should buy the legitimacy of a deference regime for the Pentagon, the CIA, NSA, or others, other players in the foreign affairs and national security context. Let's go through the different rationales that we just put on the table. The factual comparative advantage, I actually don't think this does that much work here. I don't find it very persuasive. Sometimes the executive will have a comparative advantage at knowing whether Padilla is in fact an enemy combatant. Did he in fact receive training from al-Qaeda about how to ignite natural gas and detonate apartment buildings? It's a factual question, right? To the extent the executive branch has a comparative advantage at answering that question, it's only because the executive branch has access to sensitive intelligence, right? And you could very easily eliminate that information asymmetry by the executive branch handing over the information to the court. You don't even have to give it to defense counsel, right? You could have an in-camera review as you do in the FISA context. So if the claim is we need a deference regime because the executive knows more about the underlying facts, it seems to me that a sufficient response is, okay, share the facts and allow the court to pronounce its own view on the underlying facts. So I don't think factual comparative advantage does that much work. One other side note on this point, the notion that the amount of deference that's due should depend on whether or not politically accountable decision makers actually consult with the underlying subject matter experts. I don't find that a terribly persuasive argument, simply because courts usually don't buy it in the domestic administrative law context. So sometimes the NLRB has to give special weight to the findings of its administrative law judge, right? But usually not. You only have to give special weight to an ALJ's finding if the ALJ has done something like make a witness credibility determination. It's an information asymmetry point, right? The ALJ was there in the room to see how the witness testified. The NLRB is only reviewing a paper record and therefore isn't in a position. So in narrow circumstances like that, actual participation of and actual consideration of the factual experts is a necessary predicate for the triggering of deference. But I don't see a clear parallel to that in the national security context. On policy questions, right? If the JAGs say, we think that proceeding under UCMJ is better for policy reasons or legal reasons, that seems to me to be a different inquiry than saying witness credibility determination, information asymmetry, right? But as I've said, I don't find that factual expertise rationale very persuasive, so I guess I can stop beating up on it now. Let me move on to the interpretive expertise point. I actually think this does carry some water. I think the executive knows more about the meaning of, in particular, international legal instruments than courts do. And the reason for that is because the primary role the executive plays in the formation of international legal obligations. The executive has a much more active role in the formation of conventional law, such as treaties and customary law, than he or she does, it does in the domestic law context. The positions are reversed, right? The president, through the Secretary of State, is the entity that's responsible for negotiating treaties. Well, why is that relevant? Well, it's because the executive is the primary mover, the executive is in a better position to know what it and its treaty negotiating partners likely intended when they enacted a treaty that says, for instance, prohibit all cruel, inhuman, and degrading treatment, right? Very vague and ambiguous treaty obligation. Well, I think, given that the executive was present at the creation, the executive knows more than courts do. Or at least, I can make a weaker version of that claim, the executive knows more about the likely intent of the parties in outlawing cruel, inhuman, and degrading treatment than the executive knows about the likely intent of Congress in regulating carbon emissions or other forms of pollution. The other principal form of international legal obligation, of course, is customary international law. Customary international law, as you all know, is a pattern or practice followed by states out of a sense of legal obligation. Well, it's usually the executive branch that is responsible for setting the state practice, right? And it's often the executive branch who says the reason we're going to do this is because we understand our international legal obligations to require us to do this. So again, the executive is nearer to the formation of customary law than is the case when the executive simply signs a piece of domestic legislation. So for both of those reasons, I think the interpretive comparative advantage point actually does carry some water here. The executive is likely to know more about the intended meaning of international legal instruments than domestic legal instruments. Let's talk about accountability. This is, I think, perhaps the most persuasive reason for why we have a Chevron doctrine and why it's appropriate to have something like a Chevron doctrine in the international and foreign affairs and national security context. The simple argument is more is at stake, right? Domestic regulation typically involves the allocation of scarce social resources to its various uses, right? Do we want to have more or less pollution? Do we want to have less or more economic growth, right? And those are very important questions, and I don't mean to minimize their importance at all, but the questions that arise in the national security and foreign affairs context are typically even weightier, right? What is at stake is not merely the distribution of the social pie, right? But whether we have a pie at all, right? Whether the United States will continue to exist in the international system in its present form, right? There are existential questions that come to the table in the national security context. It's critically important, I think, and even more important that these sorts of existential foreign affairs and national security questions be resolved by those who have to go before voters than it is for domestic questions to be resolved by those who have to go before voters. A final argument I'd make on accountability and why that argues for at least as strong a deference regime in the foreign affairs context as in the domestic law context is because international legal norms are usually more opaque than domestic law requirements are. So domestic law is famously riddled with ambiguous statutory provisions. Pursue the public interest in the FCC's case, or the EPA, requisite to protect the public health with an adequate margin of safety. Well, what's requisite? Right, and what's adequate? Nobody really knows, right? But those things make certain international legal instruments look like a 500-page chapter and verse exercise in casuistry, right? They are considerably less vague. Domestic law obligations are considerably less vague than many international obligations. So, for instance, the customary international law principle banning disproportionate military strikes. You have to calibrate the amount of collateral damage to the importance of the military objective. Well, there's no mathematical formula that can yield an answer to the question how much collateral damage is too much and how important is the military objective. In other words, in international law, there are often bigger gaps to be filled than in domestic law. There's huge gaps in domestic law, but I think in international it's even more so. Because the gaps are larger there, it becomes more important for the person who's filling those gaps to have to go before voters, either directly or indirectly. So how much deference have courts shown in the post-9/11 era? I don't pretend to have undertaken a comprehensive study of this, so I'll just highlight one or two cases. And I think the answer that we've seen from the Supreme Court in at least some of the detention cases is not much deference. The Hamdan case is a good example of this. So one of the questions in Hamdan is, does Common Article 3 of the Geneva Conventions apply to those who were captured in connection with the war on terrorism? So Common Article 3 says beneficiaries of these rights can claim these rights if the conflict is not of an international character. If it's an international conflict, doesn't apply. If it's not an international, wait, do I have that backwards? If it's not an international conflict, right, the provisions apply. Otherwise, they do, right? So you can imagine a court saying the following: all right, we have a conflict involving the United States and al-Qaeda. The executive tells us that's a conflict of an international character because the battlefields are not just here, they're in Afghanistan, they're in Yemen. It's a conflict of an international character in the sense that it takes place in different nations. There's another interpretation, as the petitioners argue. This is not a conflict of an international character because it's not nation versus nation. It's nation versus transnational terrorist group, and that's not conflict of an international character. You can imagine a court that says, all right, we're faced with these two equally plausible interpretations of an ambiguous treaty obligation. We therefore invoke a Chevron-type doctrine to say the executive's interpretation is reasonable, maybe not 100% persuasive, but it's at least within the realm of plausibility and reasonability. We therefore defer to it. That is not, of course, what the court did in Hamdan. The court essentially interpreted Common Article 3 de novo, extending little, if any, deference to the executive branch's interpretation. Sort of a jarring and striking result if you look at the case with the expectations created by domestic regulation and the administrative law system that we have for the domestic sphere. You can describe Hamdi and Boumediene in the same sense, but I'm short on time, so I'll skip over that for the time being. Again, we could imagine an alternative universe in which the court extends deference in Hamdan and other cases. That's not the universe we live in. So the question then becomes, why not? And that brings me to the third part of my talk, where I'd like to offer a quick hypothesis. I think the Chevron framework can actually explain why the Supreme Court has been reluctant to extend strong Chevron-style deference in the detention and military commission cases. And the key to the puzzle is the Meade case, a Supreme Court decision from a few years ago. In Meade, the Supreme Court says only certain forms of executive interpretation trigger the Chevron treatment at all. Right? This is the so-called Chevron Step 0 inquiry. You only get, so that's the second administrative law joke that we have. You only qualify for the Chevron framework if the agency in question announces its interpretation through a relatively formal, relatively rigorous procedure. So, for instance, a notice and comment rulemaking will trigger the Chevron treatment. But if you announce your interpretation in, as in the Meade case, a customs tariff classification letter, tens of thousands of which are issued every year, that is not a sufficiently rigorous, sufficiently formal process to merit the Chevron treatment. Well, you can apply that to the military and presidential determinations in the post-9/11 era. You can say maybe the problem in Hamdan is that the president's interpretation of Common Article 3 wasn't announced in a relatively rigorous formal process like a notice and comment rulemaking. Sure, it was a presidential proclamation, and there was some sort of process attendant to it, but it wasn't an open and transparent process with the opportunity to review the president's proposal by interested parties, opportunity for interested parties to submit their own views on whether this is the appropriate standard or what alternative standards might be. And actually, there's a bit of a clue that this may have been what the court had in mind in the Boumediene case. The court points out there, and maybe even in Rasool, that the military detainees held at Guantanamo Bay here hadn't been tried before a military commission. Right? And in that respect, they were different from the detainees in Eisentrager and the detainees in Kirin. Well, what's the difference between military commission and presidential proclamation from a Chevron standpoint? Well, one is considerably more formal than the other. You have a formalized process with rules of evidence, burdens of proof, right? And the court in Boumediene suggests that that sort of process might have been an adequate substitute for, in Boumediene, habeas corpus review by the federal judiciary. I want to suggest that that might be the national security and detention law equivalent of Meade. I could go on, as we all could, but I'll stop and love to hear your questions.
Thank you. So Deborah, why don't you pick up here, because I think we have a disagreement and on this question of Chevron deference. Go ahead.
Sure. So I'm curious to hear the audience questions as well. But so on the question of Chevron deference, now I should be candid in saying I'm not a big fan of Chevron in the administrative domestic law context either, right? But neither is the court, increasingly. So there's been this wonderful empirical study that was done of every administrative law case from 1984, whenever Chevron came down, to 2010, about the number of cases in which the court actually applied Chevron deference to the cases in which one would have imagined the court had said it was going to apply Chevron deference. And the answer was, gosh, it didn't do it that often, or remarkably less often than we might have thought. And part of the reason for that is, I think, because the court is also frustrated about the inability to get at the actual expert wisdom that Chevron provides, right? So the secretary wins whether or not the secretary talked to the epidemiologists about what's actually causing the diseases that are the subject of the regulation and the subject of the statute being interpreted, right? That seems like an unfortunate process, right? If part of the reason we wanted an administrative state was because some of this stuff is just too complex for Congress to have to do the studies itself, then we should actually get the benefit of the administrative state in that regard. And you can see this, for example, in the court's decision in Massachusetts versus EPA. The EPA has to interpret its statute to figure out whether or not it can regulate greenhouse gases, right? Huge decision, mammoth implications from an environmental point of view. And one of the arguments the EPA made in saying you should defer to what we think and you shouldn't interpret it in the way that you're leaning to interpret it is, look, if the EPA regulates about this right now, you force us to regulate about this right now, it'll interfere with ongoing very delicate negotiations in the international sphere about global regulation of sort of climate change and associated issues. So don't interfere with that sort of foreign relations related ongoing process, to which the court said to the EPA, well, are you involved in the international negotiations about the climate change treaty? To which the EPA said, well, no. To which the court said, well, who is involved for the US government in these negotiations? And the EPA said the Department of State. And the court said, well, have you talked to the Department of State about the impact of this regulation on the negotiations? The EPA said no. And the court said, well, then I don't find your argument very persuasive, right? That seems to me exactly the kind of logical reasoning right, that we would want the court to be able to engage in. And imposing this sort of formal Chevron sort of constraint on that effectively makes it harder for the court to actually access the meat of the arguments that, after all, is what it's supposed to be sort of engaging.
Okay, let's leave it there. Audience, have at it. Yes, sir.
I'm Andy Gilman, and I teach at the Army JAG School. I'll try the command voice. I'm a military guy, and so in the military we like clear, bright guidelines, mean what you say what you mean. But I wanted to pose a question about an alternative model of a court that recently has not shown much judicial deference to executive decision-making, and that's the European Court of Human Rights. So for those who are unfamiliar with this court, they are a supranational body that sits in Europe, and their job is to enforce the European Convention on Human Rights, something akin to the U.S. Bill of Rights, but a lot longer. And in the past decade or so, they have invalidated the military justice system in Great Britain. They have all but abolished detention without prosecution. They have declared that brigade-level operations in Russia didn't count as any sort of armed conflict. And I could go on. My point is not to criticize the court, but rather to note that this was a case where a judicial body felt it was important to declare very clear, bright guidelines with not a lot of consultation and almost no deference. A little bit like in the log cabin Republican case, one district court judge being able to issue a worldwide injunction, even while policy discussions are ongoing. And my question for you all, is that a better model? Or does that really foreclose a lot of the discussion that you would hope would happen between the branches?
Neal?
I don't know. I'm a U.S. constitutional lawyer. I don't know how this court operates. And so I'm not competent to answer your question about whether this is a better model. If the facts are as you describe them, that doesn't sound like a particularly good model to me. Right? I think we want courts that have a significant degree of independence. We also want courts that are going to be mindful of the limits of their own authority and are going to be accountable in various ways. I think some of the ways in which courts take account of the conditions of their own legitimacy is by listening to those around them, getting the advice of those around them, right? Understanding the limits on their own authority. But those are all generalities, right? Do I think courts in this country should be going around doing what you just described? No, but that's not the kind of discussion we're having here in a post 9/11 world, right? When we're talking about can the president, nothing you've said suggests to me that the president should be able to put someone, say a U.S. citizen, living in Durham, who the president determines is an unlawful combatant, and they're going to the brig in South Carolina, and they're going to stay there until further notice, right? Nothing you're describing to me suggests that it would be a judicial overreach to say, actually, the court should have something to say about that matter, right? The president shouldn't be able to do that alone. The president should be able to do that with Congress at his side.
So let me briefly say the story you just told reinforces my concerns about accountability, and I think that illustrates why we have a deference regime, or why we ought to have a deference regime. I don't think American courts are doing anything like what you've described the European Court of Human Rights is doing, and I'm grateful that courts aren't quite as the court militant, as it were, here in the United States. So let me segue into a broader observation on judicial action and accountability. I think it's true, as Deborah points out, that judicial intervention can sometimes serve accountability values to the extent that the consequence of judicial action is the provision to the public of more information, right? Transparency. Judicial action can have salutary effects on the democratic process. It can also have salutary effects in the form of forcing political branches to actually act, right? The trigger for deference in the first place. So the court strikes down the Detainee Treatment Act, and then Congress has to go back to the drawing board, right? That could be described as a democracy forcing effect. And so in those contexts, I think judicial action can actually have some salutary pro-accountability effects. But that's not the only thing courts can do. Sometimes judicial action has the effect of negating decisions by other branches and substituting a judicial decision for a congressional decision or a presidential decision. Those are the places where I'm concerned. So if the president decides we're going to send a brigade into Russia, well, the Russians send a brigade into Russia. If the president gets it wrong, there's a mechanism to hold him accountable. And if Congress gets it wrong and people don't like the way Congress wrote the statute, there's a mechanism to hold them accountable, and it's called elections. There's no comparable mechanism to hold judges accountable if they radically screw up our national security policy, either in a pro-security direction or a pro-liberty direction, right? If courts bless targeted killing after you flip a coin, right, there's no way to have that stricken from the books through an election. You can vote for new congressmen and presidents who are going to not engage in that practice anymore. But the precedent itself is still there. So
I actually, well,
I just wanted to add,
drawing fire from both sides, all right.
accountability is an important value, but if these cases were easy, it would be the only value. There are other values on the table. Where that argument ends is first getting rid of the lower federal courts, which don't have to exist as a matter of the U.S. Constitution, or declaring all national security cases non-justiciable, or electing and re-electing all federal judges and having them sit for 4-year terms or 3-year terms, right? I mean, there's accountability and there's independence. And there's a reason why we want federal courts and we want them to be independent, particularly in circumstances in which we don't have particularly good reason to trust the executive. Do we have good reason to trust the interpretive expertise of the executive about what cruel, inhuman, and degrading means? Are they just making their best efforts to figure out what's torture and what's not and comply with international law? Or is something else going on?
Deborah.
I guess I was just going to say on the original question, the accountability, it depends, right? It depends centrally on what the effect of the court's decision is. I quite disagree here. When the court is interpreting a statute, when our court is interpreting a statute or a treaty, if the court gets it wrong, there's an incredibly easy remedy, and we've seen it played out repeatedly over the last decade, right? Congress can pass a new statute and tell the court it got it wrong. Even in the treaty context, right, a later in time statute trumps an earlier in time treaty, at least as a matter of the effect of domestic law. So all the court's statement of here's how we read this has done is both compel a larger national debate. Now, Congress may act or not act, but that itself is a significant democratic decision-making, right? And it's taken some time. So maybe the concern is, well, wait a minute, you make us go back and re-legislate, and that takes forever, and in the meantime, people are dying, right? Well, in practice, it never works that way. The courts don't get cases until the event that's being challenged or the power that's being asserted is in the past. That's why, legislatures are prospective and courts are retrospective and so forth. So there may be some delay, and sometimes it's a pretty quick delay, right? Between Hamdan in June of 2006 and the MCA of 2006, there were 2 months less. They can act quickly when they want to. They did after 9/11 too. I'm not sure we're actually losing that much, and we're gaining a lot, particularly on the accountability concerns that we're most worried about.
Well, but sometimes a rasul is followed by a boumediene.
Well, right, boumediene is a really different question.
Well, let me explain what I mean by that.
Sure.
So that was just the bumper sticker. Now, let me give you the paragraph. So sometimes the Supreme Court strikes down congressional action as statutorily unjustified, right? And that's what we see in rasul, striking down portions of, or holding that portions of the Detainee Treatment Act do not, in fact, preclude judicial review. And then sometimes justices of the Supreme Court say, nothing in our opinion prevents Congress from doing it over and actually stripping us of jurisdiction to hear these sorts of cases. And then sometimes the court says, guess what? We have a constitutional entitlement to hear these sorts of cases, and Gitmo detainees have a constitutional right to bring them. So judicial action can sometimes force democratic deliberation, as it did in the first iteration, but sometimes judicial action can preclude democratic deliberation, as it did in the second iteration.
I think he's right. I mean, I think you've got to concede he's right. And I think there's something disingenuous about a court preaching accountability and then having Congress respond in kind and then having the court strike down on constitutional grounds, right, the accountability enforcing statute that Congress passed, which is why I think accountability matters, but it's not the only thing that matters, right?
Okay.
There are modalities on both sides of the line.
Deborah's waiting for her bumper sticker.
We're going to get one question from the audience. So, right, there's a distinction between when the court's doing constitutional interpretation and when it's doing statutory and treaty interpretation on the one hand and on the other. I quite agree with Neal, right? So accountability is not the only concern. It's not the only thing that matters. But even when the court engages in constitutional interpretation, right, it's not that democracy dies at that point. There is an amendment process. The number of amendments that have been introduced in Congress, right, is staggering. And even the Bermudian court leaves open an avenue. It says if you really wanted to do a process that was an adequate substitute for habeas, you're more than welcome to do that. This one, where you say the evidence of this reported decision out of Bosnia finding this guy innocent is not reasonably available to come in to the CSRT process that was created at Gitmo, that is not a reasonable substitution for habeas corpus. So our court has a sort of elaborate set of prudential ways of checking itself in the interpretation of the exercise of the judicial power, and I just chafe against even the accountability argument sort of conclusively working against it.
Well, I guess that will be the last word, a bumper sticker or not. I'd like to thank the panel very much for a very illuminating. And I'd especially like to thank our dean for taking time out of his schedule to moderate the panel and to support the conference. I would ask all our speakers, by the way, to check with Fred and so we can make sure that you have a way home tomorrow. Okay, the scheme of attack now is that we will take a 15-minute break and then we'll come back for the last panel. It's going to be very interesting. It's our international guests. They're going to be speaking, so look forward to it. Thank you very much. 15 minutes from now.
Produced by Duke University, online at duke.edu.